Hello, everyone, and welcome back to part 6 of Polity Premier League. Let's begin. First question. Consider the following statements regarding the constitutional conditions associated with the office of the governor. Number 1. A sitting member of parliament or a state legislature is disqualified from being appointed as a governor until they resign from their legislative seat. Now, this is a provision under Article 158, Clause 2, which seems to be correct. Now, just to clarify, this article specifies that if a sitting MP or, say, an MLA, MLC is appointed as a governor, they must vacate their legislative seat on assuming office. However, resignation prior to the appointment is not mandated, and that is why this statement is actually incorrect. Number 2, the governor is entitled by the Constitution to official residence without payment of rent. This is correct. This is a provision of the same article, Clause 1. Number 3, the emoluments and allowances of the governor cannot be diminished during the term of office is also correct. Same article, Clause 4. And the fourth one, the Constitution explicitly prohibits a governor from holding any other office of profit. Yes, the Constitution clearly says under Article 158, Clause 2 that the governors cannot hold any office of profit. This is also correct. Statement which is not correct. Right answer is D, 1 only. Moving on to the next question with regard to the appointment of the CM, the Chief Minister, which of the following statements is correct? A person not being a member of the state legislature cannot be appointed as Chief Minister. Now, see, as far as the statement is concerned, it is wrong. We all know very well that any person who is duly qualified to become a member of the House, whether a member of the Assembly or the Council, can be appointed as a Chief Minister without being a member of the House. However, he or she must become a member of the House within how many months? Within 6 months, right? This is mentioned under Article 164, Clause 4. I hope you remember the Nayak article. Okay, so one is wrong. The governor must always wait for the Legislative Assembly to prove a majority before appointing a CM. No, the governors will appoint the CM and then ask the CM to prove the majority in the House. This is also wrong. A person not initially a member of the legislature may be appointed as Chief Minister, but must secure membership within 6 months. This is actually correct, the right answer. And the fourth one, the CM must be elected directly by the people is nonsense, right? CM may not be a directly elected member, firstly, and secondly, CMs are not directly elected by the people. CMs are primarily the leaders of the party which have won the elections. So D is again incorrect. Moving on to the next question, simple and easy. Regarding the composition of a council in states, which one of the following is correct? The governor acts as chairperson of the council. This is wrong. Why would the governor act as a chairperson of the council? Chairpersons of councils are elected in the same manner as the speakers are elected in the, say, Lok Sabha or the Vidhan Sabha. Second one, its members are directly elected by the people. Again, this is wrong. Its members, some of them or 1/3 are elected by the MLAs also. C, its maximum strength is 1/3 of the strength of the assembly and the minimum is fixed at 40 is correct, which is the right answer. And D, it is a permanent body with a fixed membership of 100 is also wrong. By the way, there is one state which has 100 MLCs. Please type in the comment section which is that state which has 100 MLCs or the membership is 100. Moving on to the next question. With respect to the composition and functioning of state legislatures, consider the following statements. The minimum strength of a legislative assembly is 60 members, which cannot be altered even by a constitutional amendment. Now, this is wrong. We have made several such amendments, for example, say Nagaland, for example, Arunachal, Goa, etc., where we have reduced this number to less than 60 also. So yes, the minimum strength ideally is 60, but can be reduced, can be altered by constitutional amendments. Number two, the Legislative Council's term of office is coterminous with the Assembly's, dissolving automatically if the Assembly is dissolved. Firstly, the Council's term, or the MLC's term rather, is how many years? Is 6 years, just like you have the term for the members of Rajya Sabha. And number two, councils are not subject to dissolution, they will never be dissolved. So two is wrong. Third one, the constitution mandates that 12 LC members must be nominated by the governor from among persons with special knowledge. Special knowledge, yes, correct. Governor will nominate, yes, correct, but it's not 12 members. It is how many members? 1/6 members who are nominated from fields like art, science, literature, social service, and cooperative movements. So this is also wrong, which means B. None of the above is a correct statement. Next question. Under which circumstances does the governor have situational discretion that is not explicitly mentioned in the constitution? The governors have two types of discretions. One is a explicit one mentioned in the constitution. The other is an implicit one in the implied sense only. So first one, appointment of CM when no clear majority exists. Yes. Number two, dissolution of the assembly when the council of ministers loses majority is also correct. Number three, referential veto. Now, as far as referential veto is concerned, this was clearly mentioned in the constitution that yes, the governors have full right to refer certain bills to the president under Article 200. The time frame now with the new judgment has been set, but yes, it's the governor's prerogative to refer such certain bills rather to the whom? To the president. This provision has been borrowed from which constitution? The Canadian Constitution, section 55. So this is an explicitly mentioned power, not an implied one. So right answer would be A, 1 and 2. Next question. With reference to the Advocate General of a state, consider the following statements. The Advocate General holds office during the pleasure of the governor and may be removed at any time. Absolutely correct. Advocate General, Article 165, a constitutional post, and their appointment and removal is subject to governor's control. Number two, the Advocate General has a right to speak. Yes, he or she has the right to speak in either house and vote. Sadly, they have no right to vote. Voting right comes through membership. So two is wrong. The Advocate General advises the state government on legislative matters and performs duties assigned by the governor in this regard. And why would he advise on legislative matters? He would advise them on what kind of matters? Legal matters. So incorrect statements are B, 2 and 3 only. Next question. With the following statements about the relationship between the governor and the CM is or are correct. The governor cannot dismiss the CM unless the latter loses the confidence of the assembly. Absolutely correct. The governor is bound to act on the advice of the CM in all matters except those specifically reserved for the governor's discretion. Yes, Article 163, when the Constitution allows for discretion, there the governor can, of course, do what? Use his or her discretion. Number three, the governor can summon, prorogue, or dissolve the assembly only on the recommendation of the CM. Now, yes, of course, this is correct. However, the governors can dissolve the assemblies without the CM's recommendation if no party is able to form the government. We have a situation of a hung legislature. So some discretion is available there. So only might be a very harsh statement, an extreme statement. 3 is wrong. Right answer is A, 1 and 2 only. Next question with reference to the powers and functions of the presiding officer of the council, that is Vidhan Parishad, consider the following statements. The chairman can cast a vote in case of a tie in the legislative council. The chairman, of course, can cast a vote in case of a tie, no problem. The chairman is elected by the members of the assembly or the council, my bad, from amongst themselves. This is also correct. Both statements are correct. C 1 and 2. Next question. Consider the following statements about the passage of bills in the state legislature. A money bill can only be introduced in the state legislative assembly and not in the council if it exists. This is correct, of course. Money bill can be brought only in the lower house. Constitutional amendment bills cannot be initiated in the councils but only in the Legislative Assembly. Sadly, constitutional amendment bills can neither be introduced or initiated in the Assembly nor the councils, only in the Parliament. Right? Number 3, if the council rejects or amends a bill, the bill is deemed to have lapsed and cannot be reintroduced. Nonsense. Councils have no right to reject a bill. Even if they reject a bill, it does not really matter. The Assembly, if it wants to get the bill passed, the bill will be passed. Which statement is incorrect? So 2 and 3 is the right answer. Moving on to the next question. In the context of state legislatures and financial procedures, consider the following statements. The council can reject a money bill if it disagrees with the assembly's taxation proposals. Provided it does so within 14 days, there is no power to reject a money bill with the council. The governor can certify a bill as a money bill. Sadly, this is wrong. The speaker has the authority to certify a bill as a money bill. So 1 and 2 are both wrong. Right answer is D. No statement is correct. Next question. The resolution for the abolition of the legislative council in a state must be passed by the legislative assembly with a simple majority, no. A majority of total membership and a majority of not less than 2/3 of the members present and voting. Yes, this is correct. So initially, this majority is required and then it is sent to the parliament where a simple majority is required, and with that, the constitution will be modified, not amended as per Article 368, but modified, and you can add the name of the state in the list of states which will have a council, or you can remove the name of the state from the list of states which have councils. Like in this case, the question talked about abolition. So it's a two-step process. So C and D will have to be wrong. B is the right answer. Moving on to the next question, with reference to the recent Supreme Court judgment in the state of Tamil Nadu versus Governor of Tamil Nadu, consider the following statements. The Supreme Court held that a governor cannot indefinitely withhold the assent to bills passed by the state legislature. So see, the statement is absolutely correct. Supreme Court has said that the governor cannot indefinitely withhold assent to bills. The governor can reserve a bill for the president's assent even after the state legislature passes the bill a second time. No, the court has said very clearly that the governors cannot reserve a bill for the assent of president. Once it has been given back to them, they'll have to, or the governor will have to give his assent within a fixed time frame. Number 3, the judgment prescribes specific time frames for the governor's actions. Yes, yes. The judgment prescribes specific time frame, a maximum period of 3 months within which you will have to take an action on the bill. You either send it to the president or maybe return the bill, but a maximum time frame has now been fixed. So there is no pocket veto for the governors. So this means 3 is actually correct. 1 and 3 are right. Right answer is, in this case, A. Next question, which of the following is not correct regarding the Advocate General of a state? The Advocate General is appointed by the governor of the state and holds office during the pleasure of the governor is actually what? A correct statement. The Advocate General has a right to speak and take part in the proceedings, but no right to vote is also correct. To be appointed as the Advocate General, a person must be qualified to be a judge of High Court is also correct. This means not correct. D has to be the answer. Let's see. The Advocate General's remuneration is fixed by the Constitution and is charged on the CFI. Oh, interesting. It is debited from the CFS. See, the Attorney General is not some salaried government servant. He is paid a retainer and fees on a case to case basis from the CFS, not the CFI. Okay. Then the next question, which of the following is not true about the ordinance making power of governor of an Indian state? The governor can promulgate an ordinance only when the state's legislature is not in session. That is, when the legislative assembly or both houses in the bicameral state are not in session. Is it correct? Yes, of course it is correct. An ordinance is issued by the governor, or an ordinance issued by the governor must be laid before the state legislature and will cease to operate after 6 weeks from the date the legislature reassembles unless approved by the legislature earlier is also correct. The governor cannot promulgate an ordinance to amend the Constitution of India is also correct. This means D has to be the wrong answer or the incorrect statement. The governor's satisfaction in promulgating an ordinance is beyond the scope of judicial review is wrong. Ordinances are subject to judicial review. Supreme Court has said this in multiple cases, be it the R.C. Cooper case, be it the D.C. Wadhwa case, Krishna Kumar Singh case, right? So D is the wrong answer, which brings us to the last question for today. With reference to the state legislature in India, consider the following statements about a state's legislative council. Legislative council may have more members than the assembly. Now, that is not possible. The maximum limit has been set at 1/3 the strength of the assembly. Number two, the provision for a joint sitting of the two houses of a state legislature can take place only if the bill deals with matters pertaining to local government in the state. So there is no provision whatsoever for a joint sitting in the state. Both statements are wrong. D, neither one nor two is the right answer. This brings us to an end of our discussion for today. Let's meet in the next video. Till then, that is all for me. Jai Hind.